Okay. Hello, everyone. Thank you for joining us. My name is Kyle, and I'm joined by David Schwartz of Our Children's Trust, and this is our Lunch and Learn. We're going to be talking a little bit about how Our Children's Trust works with the youth of America and helps empower them to protect their rights to a secure and safe climate, or Hello, secure their everyone. Thank rights you to for a safe climate. joining us. Oh, My name is excuse me. Kyle, All and right, I I'm have my joined by stream David open. It's Schwartz of Our Children's coming back on me. Trust, and this. Anyway. So as I was saying, my name is Kyle. I'm the project coordinator here at Protect PT, and we run these monthly lunch and learns on the last Tuesday of every month. And I am joined by David Schwartz. So thank you, David, for joining us. I'm going to hand it over to him and let him take it away.
Wonderful. Thank you, Kyle. And thanks to everyone joining the event. I can't see you all, but I'm happy to have you here. I'd like to spend the next 40 minutes or so talking a little bit about the organization I work for, the work we do in Pennsylvania and other states, and to answer any questions you may have at the end. Our Children's Trust is a nonprofit public interest law firm that works primarily with youth and young people and bringing constitutional rights cases against government defendants seeking to secure youth constitutional rights to life, liberty, and a stable climate system, and to hold governments to account for actions and policies that exacerbate and further the climate crisis. The reason we do this work is because the climate crisis impacts pretty much every young person and child living on the planet today, as any of our experts will tell you. There are kind of three overarching pillars that guide our work. The first is we seek to use only the best available climate science and other scientific evidence that we present to courts in terms of the current state of the climate disruption, the sort of atmospheric carbon concentration that is necessary to achieve to stabilize the climate system and the associated impacts to young people. The second pillar is that this is a youth-centered effort. We, like I said, represent individual children and young people, often under the age of 18, but some of them are over, or they, grow to age 18 throughout the course of a case, which, can take many years. But we center their stories, elevate their voices, and make their lived experience kind of central to all the cases we bring. And finally, this is about furthering democracy and utilizing all three branches of our government and really respecting the role of the court system, the court and judiciary in a democratic system of government, and having them, ensure, carry out their role as checks on the other the political branches of government, and, courts fulfilling their function as the protectors of the constitutional rights that are enshrined. We're going to talk a bit today about cases that we have brought in U.S. states primarily, and there are a couple of states, Pennsylvania, as I will discuss soon, is one of them, that have an explicit constitutional provision to a healthy environment. There are 6 states that have those, as you'll see on the screen. We brought a case that I will discuss in a bit in Montana, and we currently have a case in Pennsylvania. And so our cases are either in state court, at least, are brought in states that have such an explicit environmental rights protection. And but also we have brought plenty of cases in states that do not have those specific environmental rights protections. And instead, we bring our claims under your quote unquote traditional constitutional provisions, the due process clauses or the equal protection clause. So being that many folks here are Pennsylvania-based, I would love to get the chance to talk a little bit about our current case in Pennsylvania, McIntosh versus the Pennsylvania Department of Environmental Protection. This was filed late last year it's an appeal of the Pennsylvania Department of Environmental Protection's issuance of an air permit for a massive gas-fired power plant that is part of the Homer City redevelopment project. Many of you may be familiar with um, the ongoing development of data centers and associated power plants or electricity production facilities. Data centers require massive amounts of power, and often for the largest scale data centers, they are being co-located with an on-site power plant. And that is the overall project this case involves. It's an appeal to the Pennsylvania Environmental Hearing Board of the key permit for the massive gas-fired power plant part of this project. This is, the redevelopment of the Homer City coal plant that has now been demolished. When this project was proposed, I believe in 2024, the power plant, the gas plant here, what would be the largest gas power plant in the country. It is no longer holds that distinction. There's another project, I believe, in Texas that is slightly larger. But the emissions authorized under this permit are substantial. You see here over 17.5 million tons of greenhouse gases annually, which is larger than the countrywide emissions of over 100 countries on Earth from just this one plant. And it is intended to power a data center. Largely, I believe like 90% of the power from the plant would power the data center. The rest would go to the grid, but massive amounts of electricity. You can see here the coal plant being demolished on the left and the kind of artist rendering of what the power plant with the gas. These are the gas turbines. And an aspect of this is that the stack heights on the smokestacks are much shorter for a gas plant than for a coal plant, which can allow the emissions and pollution to sit closer to ground level. And so the McIntosh appeal, like the work we've done in many other states, obviously raises only constitutional claims, and Pennsylvania having its environmental rights amendment that you see on the screen here. This is the kind of central claim in the case. Essentially, the case argues that the Department of Environmental Protection's approving the permit, issuing the permit to the permittee to build and operate, at least initially, this gas plant violates our client's rights under the ERA and violates the department's obligations under the ERA. But that is not the only constitutional claim that we have raised here. We've also raised substantive due process claims under Article 1, Section 1 of Pennsylvania's Constitution, arguing that the impacts to Pennsylvania's environment and the harms to plaintiffs they are experiencing as a result of climate change infringe upon these due process rights, and the issuance of the permit contributes to that harm. This case involves 15 young people, a much younger cohort than a lot of our cases, as you see here, between the ages of 2 months and 21 years old. Most of them are under the age of 18, but a lot of really compelling impacts that they have related to us, heat waves, floods, the inability to engage in, like snowshoeing or ice skiing during the winter due to changing temperatures. And, on the basis of what climate experts tell us, the case alleges and makes central the fact that every additional ton of carbon dioxide from this project will worsen the already disruptive harms that the plaintiffs are experiencing right now. And, an aspect of the case is the fact that there are abundantly available and cheaper per megawatt hour alternatives that this project could be powered on. It would require some planning, but it could be done through a combination of wind, solar, battery storage and the like. There are non-fossil fuel methods to produce the electricity to power a data center. We are asking the Environmental Hearing Board to vacate the permit and to declare um, would be a first kind of under Pennsylvania law, but to declare that the right to a stable climate system is part of the ERA's protections and part of the kind of part and parcel necessary to the realization of the due process rights under Article 1, Section 1. No Pennsylvania case either with the EHB or with the Pennsylvania Commonwealth Court or Supreme Court have kind of squarely addressed that. And so we're teeing this case up to seek those sorts of legal declarations. I think helpful for our case is the fact that the Pennsylvania Department of Environmental Protection, for years has been publishing reports, legislatively mandated, both of the climate impacts assessment and of kind of Pennsylvania's greenhouse gas accounting. So they have these reports that evaluate and measure the greenhouse gas emissions across Pennsylvania's economy. And then they have this second reports that are quoted here that kind of analyze and categorize and forecast the impacts that climate change is having on Pennsylvania. And they can't feign, the DEP can't feign ignorance. It is known for decades that the impacts of climate change are severe and are occurring now and will get worse with additional levels of fossil fuel emissions. And so we are in the midst of this case right now, filed late last year and amended the complaint right before the new year to add on to plaintiffs who are based in Indiana, Pennsylvania, so within 7 miles of the proposed project. We are in the early discovery phases of the case. That's where the parties request and exchange documents and information from one another, and we're in the midst of finalizing and working out kind of procedural aspects with opposing counsel for the department and the permittee. So we're hashing out the kind of schedule our case will proceed along, when depositions are going to be conducted, when expert reports are due, things like that, when discovery should be finished. And then we are also hashing out the finishing touches on the kind of nitty-gritty of how, since most of the documents we are requesting are electronic documents, not like physical paper, hard copies, it's helpful in cases like this where that's the bulk of the information that's going to be sought in discovery to have an electronic discovery plan that, the format that documents are saved in, how they're preserved, who's going to be in charge of looking for them, things like that. So we're in the midst of that. And a very recent development is that, as I'm sure as many of you may know, there's a second appeal to this permit to the plan approval for the gas plant here. So there's the OCT youth appeal, and I should note, I should have said this initially, but BR OCT is bringing this case along with our local counsel of the Gibble, Crable, and Hess law firm. Jason Asbell is our local counsel there. Sorry, I should have stated that initially. So there's the youth appeal, and there's the appeal brought by Clean Air Council, Penn Future, and Sierra Club. That Clean Air Council appeal primarily focuses on statutory and regulatory aspects of the project. So claiming that certain aspects of the technical features of the permit, like specific emission control measures or the DEP's analysis for an emissions related aspect of the project, violate state law or state regulation. And in either late February or early March, the permittee made a motion to the Environmental Hearing Board to consolidate or to combine the two cases into one appeal. And both counsel for the youth and counsel for the Clean Air Council opposed that motion, arguing that the claims are largely distinct. Uh, you know, the statutory regulatory claims on their side, the constitutional claims on our side, and that the Clean Air Council appellants and the youth appellants are kind of seeking different case management timelines. Um, and so the board issued an order on March 23rd denying the motion to consolidate, really doing a good job in recognizing the distinction of the youth claims from the Clean Air Council and Sierra Club Penn Future claims.
David, just to interrupt you for one moment, I just want to bring up a point here. We do a lot of legal litigation, or at least have in the past here at Protect PT. And something that we've, noticed, and just for audience members out there, is that it can be time, it can take a lot of time. It's a slow process, and the legal route is not necessary, is a great one to take, but, people need patience. And that's something that we've noticed is that while this, uh, these, people, the DEP has been putting out a lot of they put out the leachate report recently as well, showcasing that there's no radiation, in leachate from oil and gas waste, which, we know is not true. So it's been unfortunate to see the hypocrisy from as well from the DEP, but it's nice that we've been seeing some progress in this case, and it's exciting to see a change. So thanks for bringing that up, and I just wanted to point out that you guys are doing really important work here.
Thank you. We
Yeah.
appreciate it, and obviously appreciate all the work that Protect PT does on the ground.
Mhm.
Um, it's okay. I will now shift slightly. If you're interested in learning more a little bit about the Pennsylvania case before I shift, there's a little QR code you can scan. I'll keep it up here for a second or two more. And like the bottom notes, if you're interested in kind of signing up to our mailing list, you'll receive case updates, opportunities to get involved. We're always looking for, you know, um, attendees at hearings and rallies or volunteers. If you're a law student or a practicing attorney who's available to assist with research or more substantive projects such as amicus briefs in litigation, those needs are constantly arising. So if you're interested to get involved in a volunteer capacity, we would be more than happy to chat and explore that. So please feel free to reach out through the QR code, or you can contact me. I can put my email in the chat at the end of the presentation. Um, there we go. Just a little bit about some of our other cases, and I want to make sure I leave time for some Q&A. But another case we brought that was premised on a state explicit right to a clean environment was our Held versus State of Montana case that we litigated at trial in the summer of 2013. That was the first kind of constitutional rights-based climate change trial to go to trial in United States legal history on behalf of 16 Montanans who challenged the constitutionality of various statutes that were on the books of Montana, one of which prevented state agencies from considering greenhouse gas emissions or climate change in environmental reviews that the state has to conduct under state law when issuing permits. And I'm covering this very fast, but there's a lot of ground. I could spend an hour on all of this, but after trial, the court ruled in the youth's favor with an amazing 103-page opinion going into the factual evidence that we put on at trial in terms of climate change, the impacts to Montana, the harms to Montana youth generally, and the harms that these individual plaintiffs specifically were experiencing. We successfully defended that win on appeal, and the Montana Supreme Court issued its decision in December of 2024, affirming all aspects of the district court's order, holding at the Supreme Court level, right, the final word on Montana's constitution that the right to a clean and healthful environment in Article 2, Section 3, and Article 9, Section 1 of Montana's environment includes the right to a stable climate system, and that the statutes that the state had passed violated that right. And here's Ricky, our lead plaintiff. So, we're hoping that cases like Held will have influential precedental value in both the McIntosh case due to the kind of similarity of the Montana's environmental rights provision and Pennsylvania's, but also in other states that have comparable environmental rights provisions. And of course, um, we hope that the reasoning of these opinions and like the demonstrated proven harms to youth and to the state's environment can be influential in other climate litigation, even in states that do not have environmental rights provisions in their constitution. Another case that we are working on now is in the state of Florida, a state that does not have an explicit environmental right in its constitution. I'm also one of the counsel on this Florida case. This is Delaney, with whom our lead plaintiff and with whom we have worked for many years. She's a rock star in Florida environmental circles, and is working on a PhD in, I believe, like coastal issues and sea level rise and coastal resiliency matters. This case is on appeal now to the Florida First District Court of Appeal. We're appealing the district court's grant of a motion to dismiss. So this case focuses on Florida's electricity sector. So the appeal is ongoing. So stay tuned for more news there. Not a state case. This is changing gears a little bit, but we have an active case right now against the Trump administration. This is a case that is in federal court. I'll explain currently before the United States Ninth Circuit Court of Appeals. This case, Lighthizer v. Trump, challenges 3 of the Trump administration's executive orders relating to energy and fossil fuel production. You'll see here that these raise your Fifth Amendment right to life and liberty claims, also challenges the executive orders as ultra vires, which is legal terminology for, in excess of authority, and raises kind of Fifth Amendment state created danger claims that the government's essentially collectively, these 3 executive orders put the full weight of the federal government on the scale in favor of fossil fuels, authorizing agencies to unleash and increase the permitting of fossil fuel projects, acts as a block to wind, solar, and EV development, and dismantles the climate monitoring and climate science regime that the United States has built essentially since the post-World War II era that, allowed the United States to become the preeminent scientific monitoring country on Earth. And so that's what is at issue in this case. And we have oral argument soon before the Ninth Circuit Court of Appeals. That oral argument is coming up in just under 2 weeks on Monday, April 13th in Portland, Oregon. We are appealing the district court. So this case Lighthizer was filed in the United States District Court for the District of Montana. The judge dismissed the case on the redressability prong of standing, finding that while the plaintiffs had demonstrated through expert testimony and their own personal testimony at a 2-day hearing, they had proven that they had been harmed as a result of climate change and the increased fossil fuel emissions that these EOs cause, that the EOs are connected to those harms. But the court ruled that that an order it could issue would not specifically redress those harms due to in part, the scale at which these EOs are being implemented across the federal government. Obviously, we feel that the district court's reliance on the prior Juliana litigation that I'll explain in just a moment was misguided and incorrect. We have briefed and we're going to argue that issue before the Ninth Circuit in just a little bit. District Court, to its credit, invited explicitly said, should the Ninth Circuit feel that I am wrong, I would gladly accept this case back on remand and allow it to proceed to trial. So inviting the Ninth Circuit to overturn him should it see the matter differently, and we are going to be urging just that at oral argument. And many of you may be familiar with the long-running Juliana versus United States litigation. This was one of OCT's earliest and flagship cases against the United States federal government on behalf of 21 plaintiffs. This case, like many of ours, has a very long and detailed procedural history that I could spend, an hour on covering just that. But essentially filed in, I believe, 2015 or 2016. The district court did not ultimately denied the federal government's motion to dismiss that case. Now, remember, Juliana was kind of a challenge to 50 years of the United States's actions and policies to implement the fossil fuel-based energy system, raising due process claims and public trust claims. And so the district court judge denied the government's motion to dismiss, but after a ping pong and repeated appeals, both up to the Ninth Circuit and to the U.S. Supreme Court, the case ultimately was dismissed by the Ninth Circuit in a 2020 order granting the federal government's petition for a writ of mandamus. And following that, the Juliana plaintiffs amended their complaint to remove requests for injunctive relief. And then again, that was litigated up to the Ninth Circuit, and then a different Ninth Circuit panel ultimately dismissed that amended complaint, although the district court would have allowed it to proceed. So essentially, the Juliana litigation has ended in U.S. courts, but continues on in an international body, the Inter-American Court for Human Rights. A petition was filed on behalf of a number of the Juliana plaintiffs in the Inter-American Court, alleging violations of the Inter-American Treaty on Human Rights and the way the case was handled and the government's conduct being challenged. So the case lives on in the international law context, and that petition was filed late last year, and we are in the process of proceeding through that process. I am not an international lawyer, so I can't talk too much more about that. But yeah, the Juliana plaintiffs continue their struggle to make their demands heard and have a court recognize their rights. And finally, I want to talk about an amazing settlement agreement we achieved in our Hawaii case, the Navahine versus Hawaii Department of Transportation. That case was filed and challenging the kind of totality of Hawaii's transportation system. Hawaii, to its credit, had passed a number of laws requiring the decarbonization of the transportation sector, and the planning and implementation done by the DOT was kind of prioritizing road development and additional lanes that would increase, private passenger vehicles, and the state was not on track to achieve its legislatively mandated emissions goals. And Hawaii also has a right to a clean environment in its constitutions. And so we brought this case on behalf of a number of Hawaiian youth, claiming that the manner in which the DOT was implementing the transportation sector violated the Constitution and state law. And this case was litigated up to the eve of trial. It was ready to go to trial in the summer of 2024. But a couple weeks before trial was scheduled to be held, the um, governor and the DOT and the state came to the table, and we were able to reach really a first of its kind of akin to Montana, right? Like the first climate change trial. This really like the first major settlement agreement between state government and young people regarding climate change and the state's actions as relates to climate change and energy use, at least in the transportation sector. The settlement agreement is amazing for a whole number of reasons, but three of the key ones here, it affirmed and recognized the right to a stable climate under Hawaii's constitution. It reiterated and affirmed the best available climate science that our experts have consistently pointed to, recognizing that a stable climate system that is consistent with the protection of human rights is governed by an atmospheric carbon concentration, not a temperature target, um, of 350 parts per million by the end of the century. That would lead us to around 1 degree centigrade of warming above pre-industrial levels. And the state, agreed to decarbonize under this settlement agreement, agreed to decarbonize Hawaii's transportation system, ground, sea, inner island air by 2045. And I think a key aspect of that is that the court retains jurisdiction until that time or until that decarbonization is achieved. And so rather than if the state were to ever be in non-compliance with the agreement, the plaintiffs would be able to proceed directly to court and not have to file a new case to enforce the agreement. It's just really, really something special. And it's really, as you can see here, it's really altered how the DOT has gone through its project evaluation and methodology. There's been a pathway established for direct youth participation in this youth transportation council. The, you know, the fruits of the settlement agreement are immediately apparent, and it's amazing to see being played out in real time on the ground through the kind of alteration of Hawaii's transportation planning. And so it's wonderful to see uh, this being carried out, going into effect, and the DOT really stepping up and carrying out its obligations. And I'll just leave it here with a quote from the Juliana opinion. And this is, kind of what we have been striving for in our work. Like, this is the Hawaii settlement, the Montana win. And, likewise is, underscores like what can happen when the judiciary fulfills its role as the answering thorny constitutional questions as relates to the fundamental rights that our Constitution guarantees. A right is kind of meaningless unless there's a body there to be able to enforce it against the wills of the political branches. And another kind of sign up or opportunity for, especially for young people on this call. If you're interested in getting involved in the work we do, although not necessarily in like a plaintiff capacity, we have this Youth Climate Rights Corps that we are working with on kind of the political advocacy or kind of organization uh, coalition building side. And so if you're interested to learn more about that, there's an action toolkit you can use the QR code for, or there's a sign up uh, list. We are also highly tech savvy. You can follow us on social media. I believe that is our handle on all socials, Instagram, Twitter, and the like. We have a wonderful dedicated communications team and a rock star. Um, they're just wonderful. And so please feel free to give us a follow. And that's I wanted to make sure I have leave time for Q&A, and it looks like I'm just a little bit of past the half hour. Um, that's my email. If any of you are interested in reaching out to me personally, I'm happy to answer any questions you may have. But with that, I wanted to ensure that there was enough time for Q&A so I can turn it back over to Kyle to moderate that portion.
Yeah, thank you, David, for that amazing presentation. If you guys joined us here at the end or in the middle, whatever, that will be available on our YouTube channel. So this will be available at the same link you're at now within the next hour or two after this finishes up. There aren't any questions in the chat, but I do have some questions for you. So going back to the slide that you showed, all of the states that had different the different laws and protections for the climate. Here in PA, that's in our Constitution. That's awesome. That's what we want to see. But in your opinion, what makes a strong protection for the climate like we have here in PA? What in your opinion is the best case scenario for trying to put protections into a state's constitution or law?
Mhm. Sure. So I think there's a couple things. Like it's uh one in terms of placement. It's very helpful if the drafters and framers of the Constitution place the environmental rights provision amongst um the other Declaration of Rights or in the kind of Declaration of Rights section. So like typically most states, that's right, like the first section. So like Article 1, at least in Pennsylvania, in Montana, Article 2 is the kind of fundamental rights section of the Constitution. And so in a general sense, it's very helpful if the environmental right can be contained in amongst the rest of the fundamental rights, because in legal terms that courts have held that like if it's in this article, it's fundamental. And when a right is fundamental, a higher standard of review, judicial review applies. There's and not to get into the weeds, but to get into the weeds, like when constitutional rights are evaluated, at least in substantive due process or the equal protection aspect, courts have essentially a three-part standard kind of ladder of review. Rights that are not fundamental are evaluated under kind of a rational basis standard, easy for the state to achieve. They just have to show that it has a rational interest in addressing this or that issue, regulating the topic, and that the means it has done going about to do that are kind of rationally related to that end. There's an intermediate standard that courts have applied in the context of, um, I believe, gender and sex-based discrimination, and for fundamental rights like religious liberties, voting, um, and others, that has to satisfy the highest strict scrutiny standard. The law has to be narrowly tailored to a compelling government interest.
Makes sense.
And so, yes, at least the first part of
That
your
makes sense.
question,
Yeah.
it's helpful if the right can be contained in the fundamental rights section, or at least be declared by a court to be fundamental. And then I think a second helpful feature is just the some of the language, like Pennsylvania's. It's helpful if they are, you know, short, snappy, and to the point, kind of the less is more. But if it can declare that the people have a specific right, and if it can um, provide for state duties or obligations, the state shall take measures to realize or enforce the right. Those kinds of that combination of like the right exists and it's held by the people, and the state has corresponding obligations to realize that right. Those kind of provide like the really key kind of two-pronged
Right. Yeah.
basis for a very strong provision.
That makes perfect sense. I mean, it's good to know. It's nice to see pieces of law and that are in front of us that actually feel as if they're designed to protect us, the people, the ones that are living day-to-day lives and spending time outside. So a good answer, yeah. And you can see that right here in the words just in front of me, like right to clean air, and then further at the end talking that the Commonwealth has the responsibility to conserve it. So thank you, yeah, thank you for that answer. I also wanted to ask about the Hawaii case that you guys had, which seems to be a tremendous success. It's something that is great precedent for other places. What has made that specific case different? I mean, what's made them more willing to work with you? Is it just a matter of the culture of the state? Is there more community action? What do you see there that's different than other situations?
Yeah, that's a good question. I think it's a mix. It's probably a mix of things. I think it's a mix of the state uh, having a kind of imbued cultural tradition of environmental protection and conservation, of a necessity, due to being an island chain. Um, the fact that the Constitution has environmental related provisions in it and protections with recognition of right, corresponding obligations on the state. And then I think, at least in like, not relating to like traditional Native Hawaiian kind of long-standing cultural traditions, but just in like the political reality of the Hawaiian government now, the over the years, the state has passed a series of legislation pertaining to energy, environment, decarbonization, and I think like I was discussing, like a key kind of uh, foothold or like climbing hook that we were able to grab onto as a basis for the case was the fact that like the legislature had passed a couple of laws requiring the decarbonization of the transportation sector. And when we brought the case, it was like the evidence was clear. It's like this
Awesome.
here's where the state says, transportation needs to be in terms of emissions by X year. Here's where they are now. Like that, the math isn't mathing. Like they are not in track. They're not in compliance. They're not in track to achieve what the legislature has said the state needs to do. And the court, that's like a bread and butter situation for a court to, the
Yeah.
court says like, sure, transportation policy and whatnot may be complex. However, the legislature has set a specific target for the state to achieve. The court can declare that the state's not in compliance with that.
Right.
We can say, declare the law. We can say like, you're not on track. You need to change what you're doing, and then leave it to the agency to figure is that out exactly. The court doesn't have to get involved in the minutia, but it can at least on the front end say, yeah, you have this obligation. You're not meeting it. You know, figure it
Awesome.
out.
Yeah. That that's awesome. So it's like a perfect, I would say perfect storm, but that's the wrong analogy. It's a perfect example, so to speak, of what can happen when you start to get involved in the spaces of holding our own governments accountable. It's cool to see that they were willing to listen and follow the things that they had even put in place. So yeah, David, I wanted to thank you again for your time. I wanted to give you one more opportunity. Is there anything else you wanted to shout out or anything you wanted to mention here before we close up?
I think, yeah, I'll just say, please, if anyone is interested, the oral argument before the Ninth Circuit in Lighthizer will be streamed, I believe, on the Ninth Circuit's website. I don't have a link immediately in front of me for that,
I got you.
but I believe uh, you can find that. But we encourage people to tune in. That'll be a very important oral argument in terms of the at least these three EOs and federal climate rights-based litigation in general. So we appreciate all your interest and support in our work. We look forward to continue to engage with Protect PT and Pennsylvania like-minded orgs and individuals, and as we work through the McIntosh case. So you'll be hearing a bit from us over the coming months and years. So thank you all.
Yeah, thank you guys so much for joining us.